A couple of days ago, this lady reached out to me and explained to me how she was tricked into facilitating certain transactions, because of which she was an enabler without her knowledge into certain criminal transactions. The police reached out to her after registration of the FIR. She had gone and joined the investigation. She gave her statements about everything and about who the actual perpetrators are and what information she has about the actual perpetrators. After that, she had come to me and sought my advice. She asked me what to do. I told her that, according to me personally, she should be seeking anticipatory bail. Because when you are involved in a crime and you are innocent and the perpetrators are not traceable, or maybe the perpetrators have bribed the police, or maybe the perpetrators have structured the transaction, the criminal transaction of cheating in such a way that you can also be charged with an offense, or maybe you could be deemed to be the main perpetrator. You need to apply for anticipatory bail, go to court and show all the evidence of your innocence. However, I also explained that it's a double-edged sword. If at this point of time the police consider you a witness and not an accused person, if you apply for anticipatory bail, they will definitely say that we now wish to charge this person as an accomplice and someone who, at the very least, under common intention, section 34 of the Indian Penal Code, was also involved and is also guilty of the offense. The lady told me that she had some very, very good connections with some particular higher up authority in the police, and she had gone through that reference, and that is why she does not wish to apply for bail, because in all probability she will not get arrested. We discussed overall legal strategy. I also told her that she should approach the courts of law against the perpetrators themselves and try to initiate in the courts of law criminal proceedings, civil proceedings, to show her bona fide, to show that she has everything with her, to prove her innocence, and to, in fact, being a victim herself in certain ways, to go and seek her legal remedies as well. Because when your evidence, whatever you have submitted as an accused person, as a complainant, or even as a witness, whatever you have submitted to the investigating officer in a matter, it is completely the prerogative of the investigating officer, the police official who has been charged with investigating the allegations, to keep in the case diary whatever they like, to keep out of the case diary whatever they do not like, and of course their own motivations, the motivations of the investigating officer, play a huge role in what is there and what is not there in the case diary and ultimately in the charge sheet. In any case, I digress. The main point of this video I will be coming to soon enough. An associate of that lady then reached out to me approximately 10 days after that meeting and told me that this lady had again went in to join investigation, and at that point of time the investigating officer took her in custody. So the person asked me now what is to be done. And I explained to the person that once an accused person is arrested in a non-bailable offense, and of course most severe offenses such as cheating are punishable with severe terms of imprisonment and therefore are non-bailable offenses. And because they are non-bailable offenses, you as a police officer can arrest a person, but you cannot release them on bail because they are non-bailable offenses. But non-bailable offenses does not mean that the person cannot be granted bail at all. Non-bailable simply means that the police cannot grant them bail, and it must be a court of law, the competent court of law, to grant bail to that person accused of a non-bailable offense. And I explained to this person that the only thing that you must focus on right now immediately is to apply for bail of this lady, this associate of yours. The person said, sure, we'll be doing that. We've hired a lawyer. I said, great. Approximately 10 days after that, he again reaches out and says, the police are investigating. When can they release her? And I was stumped. I asked whether bail has been applied for this lady or not. He said, not yet. the lawyer that we have hired has not yet filed for bail. I said, leave aside everything. First and foremost, apply for bail. The person says, all right. And then another 5 or 7 days later tells me that the investigating officer is doing ABC thing in this matter, and interrogated the lady. What are we supposed to do? And then I was again stumped, and I asked, what about bail? And the person said the lawyer has still not applied for bail. And at this point I completely lost it, and I just told the person that nothing else matters. No investigation, no interrogation, no new evidence matters. Once the police has arrested you in a non-bailable offense, they cannot release you. And even if they could, they will not release you, because they don't care about your well-being as much as fingers being pointed by higher up officials on them, the investigating officers. Why did you let this accused person go? And so even when this lady's lawyer finally, hopefully in the next year or so, finally gets around to filing the bail application for this lady, the police will still, even if they have ample evidence showing that she is completely innocent, she's a victim instead of an accused person, the police will still not say we are okay with her being released on bail. The police will fight tooth and nail in securing her custody till the conclusion of the trial, and hopefully they will hope for a conviction as well. In any case, the point of this video was, once a person is arrested, the most important thing for you to do is to apply for bail. A lot of times, well-wishers of the family, lawyers perhaps with not as much experience, tell the person that you should not apply for bail right now and wait for the charge sheet to be filed. But if you're in custody and the police are investigating and you do not apply for bail, the charge sheet can be filed up to 60 days, and in some occasions when it is very, very grievous offenses, up to 90 days by the police officer. And of course, if the charge sheet is not filed in time, you are entitled to statutory bail. But on most occasions, the police officer will file that charge sheet in time, and once they do, the matter will be committed to trial. Of course, your chances of getting bail become a little better if you are in custody and the charge sheet has now been filed, because now an additional ground for grant of bail arises, which is that the investigation is complete. But if it is a grievous enough offense to keep you in jail during the investigation, in all probability the next line of argument of the state, the police, will be that there is a good probability that the accused person, if released on bail, if enlarged on bail, will try and influence the witnesses and tamper with the evidence. And if you wait till the examination of the witnesses, then God save you, because there is no time limit set by the statute or by any jurisprudence that if within this much time the trial does not conclude, the accused person will be released on bail. I personally know of a handful of accused persons, former clients, who are still in custody because the witnesses are not examined yet, because the past 1.5 years have gone only and only in pandemics. And the situation, let me tell you, was not any better even in the pre-pandemic days. Witnesses would be called after 1, 2 months, 3 months after the after the charges are framed, and multiple adjournments are sought, sometimes because the witness is not available, sometimes because the public prosecutor is not available to conduct the examination in chief, sometimes the defense counsel is not available to conduct the cross examination, sometimes the accused person is not available because he was not brought from jail in time, sometimes the judge is on leave, the stenographer is on leave. And these 6 are the main reasons. Then of course there is court strikes. So I can think of 7 right now, but I'm sure if I think for 2 minutes before starting a video, the videos will not be too long, and B, I will be able to give more reasons for delays. And that is why you cannot wait for any of these occasions. There have been a lot of occasions where someone says it's such a grievous offense, we don't really have a budget either. Should we not wait for the charge sheet to be filed? On most occasions, I say you never know what stroke of luck you might get, what kind of a judge you might get. If you try your best, you never know. Even in the most grievous, heinous of offenses, people have secured anticipatory bail. They've been able to stay out of jail, and they've also secured regular bail if they were unfortunately arrested by the police. Even in the most heinous of offenses, the courts do from time to time appreciate the jurisprudence given to us by the Honorable Supreme Court, which is that bail and not jail is the rule. Bail is the rule, jail is an exception, something like that. And therefore, it all boils down to this. If there is a criminal case registered against you, if you are arrested, or if you are apprehending arrest, do move the courts immediately. I remember in another prior video, I talked about this occasion, this person who had consulted me, who was facing a false rape case by his former girlfriend because he refused to marry her. He applied for anticipatory bail at the Sessions Court. It was rejected, and he surrendered before the court. And then he had to agree to marry the girl, and that is why he was released after, I believe, around a month or 2 months. And as I said in that previous video, every single step of the way, keep applying for bail. You never know where luck strikes you, because at the end of the day, of course, it is the hard work of your lawyer, the facts being in your favor, and to a little extent, luck also, playing a part in it. Even if it is a very, very severe allegation, I say, give it a shot and try to secure your liberty as much as possible, because I keep saying it again and again. In criminal cases, on most occasions, it's only bail that matters, and if you have a half-decent lawyer, you will be able to secure an acquittal for yourself, especially if you are falsely accused.